Let us begin. Good afternoon, everyone, and a very warm welcome again to another ECIPE seminar on the EU's proposed Digital Markets Act, the DMA. Today, we want to talk about the impact of the proposed regulation on innovation and against this background, assess the quality of the DMA's proposed rules and obligations. Now, some of you may ask themselves, how do you assess the quality of regulation? And according to the OECD, the latest recommendation on principles of good regulatory design, innovation requires an agile and resilient regulatory approach. Governments should therefore, according to the OECD, develop regulatory models that bolster innovative activities, and they should avoid using tools that, and I'm quoting here, historically have not been particularly agile. The OECD highlights in this context that innovators often face difficulties in identifying and interpreting applicable rules when innovation is blurring the boundaries of traditional market definitions. Now, the DMA goes to the heart of innovation. It is a new, and I would call it experimental type of regulation that targets highly complex technology and services. EU policymakers are therefore confronted with matters that are difficult to place in conventional models of regulation, such as, for example, traditional network industries or plain vanilla product safety policies. In a recent ECIPE study, we looked into the DMA and several laws that are considered or implemented in Germany, the UK, and also the US to assess the quality of regulation. Let me share my screen with you. You can access this publication on our website. It looks like this. When we did this analysis, we analyzed the structure and the quality of these regulations. And I think it's important to say that not if these regulations go into a certain ideological, political, or commercial direction, but from a good regulatory design perspective, following the OECD's template on good regulatory design. And we found that there are some areas where the EU could actually learn from our proposals to make the DMA more fit for purpose and to avoid unintended consequences on Europe's economy. We recommend, for example, that the DMA's objectives should be narrowed. The definition of affected platform services should follow a more functional definition, taking into account, for example, network externalities. Gatekeeper definition should be clarified, as should be the DMA's obligations. The report is, as I just said, accessible on our website. Our distinguished guests today are two scholars from economics and the legal sciences, two experts with whom we want to discuss these aspects and additional challenges of the DMA. We first have Professor Marshall van Elstein, who is a professor of information systems at the Castrum School of Business at Boston University in the United States. Marshall has written extensively about platform business models, innovation, and disruption, and he's also the co-author of a best-selling book that is called The Platform Revolution. And our second guest today is Professor Thorsten Körper, who is a professor for civil law, competition law, and the law of the digital economy at the University of Cologne, Germany. Thorsten is a leading scholar in competition law, not only in Germany, but also internationally. And he has written extensively about antitrust cases and cases against technology companies and platform regulations in the past. I would now like to invite our two guests to give us some brief 2-minute introductory comments before we go on with viewer answer questions. And I would like to open the panel to the audience in the final quarter of the hour. So please, dear audience, put your questions in the chat box so that we can get back to them in the last 15 minutes of our panel. So without further ado, let me now hand over to Marshall for his introductory remarks. Marshall, the floor is yours.
Well, Matthias, thank you so much for that. Let me just share a few opening comments and 2 or 3 opening slides just to give you an idea what I have in mind. One of the interesting challenges about platforms in particular, here we're using a little bit of an American thing. I suppose I should be using soccer here, but here it's the umpire is on the team of one of the players. And all too frequently, in the case of these platforms, they get to make the rules, they get to decide the rules, and they are also playing by those rules. So it's not necessarily particularly fair. And this is true for Amazon. It's also true for Google and Apple and the other platform companies. With respect to the DMA specifically, what's the goal of the DMA? And I would argue that the goals are noble, but it's actually missing what I think is one of the most important goals. And so I think what Matthias has said is correct. We need to elevate the discussion by focusing on something else. So what they've done is to focus on the 2 questions: how to create fairness in contestable markets and how to create competition in there. And I think those are worthy questions. But I think the question that really needs to be asked, especially if we're focusing on innovation, is how do we create wealth or value, then decide how to allocate that value. So I think the first thing we need to do is to make sure that we protect innovation, we protect wealth creation, as you mentioned in network effects. I think there are several different methods for doing that. I gave a quick summary of what I think is great and what could be improved in the Digital Markets Act. I'm delighted to go into details on these. My own quick summary is that there's some wonderful clauses or portions of it, such as limiting the parity clauses, the most favored nation clauses, increasing transparency, fair uninstall, letting the users set the rights, the defaults, and interoperability. On the flip side, there are several things I think that need work. One of these is the inability to combine data sources and opt in. I'd flip that to opt out in order to capture more of the network effect benefits in conjunction with something else. One I hope we will spend a little bit of time on today is data portability. This has been argued as a means to increase the competition or give users rights or give merchants rights in their own data. There's a far more compelling right, which we propose, which is an in situ data right. I'm hoping we can actually spend a little bit of time on that, where I think gives users even more power and will create the kinds of competition that we want. Also, slight difference in approach. Rather than having on-site inspection for some of the platforms, maybe we can actually use openness and transparency in ways that competitors who are thoroughly motivated to keep an eye on the platform, on each other, would be able to report on the misdeeds and thereby solve the moral hazard problem. So platforms are less likely to engage in anti-competitive or improper behavior. So there's several different areas that I think can be improved. I'm delighted to go into any of these. I hope we'll spend a little more time on them, but let me turn this over to Torsten so he can make a few remarks before we take it any further.
Okay, thank you very much. I've prepared for more like 10 minutes, but I'll try to reduce it to maybe 5. I find it very interesting that the DMA now is at it's kind of a turn in antitrust approaches towards companies that in some ways reminds me of another turn in the 1890s when the United States introduced the first modern antitrust law. There was a fear of big businesses. It was about oil and railroads back then, and now it's the digital economy. So in a way, history repeats itself. But we are at the point at which maybe antitrust law or competition law, which was introduced back then, seems to be not enough, or seems not to be able to cope with the new challenges of the digital economy. And at the same time, I think the DMA is also driven by the wish for European champions in a way. The EU has found out that there are only American companies and maybe Chinese companies who are the big players, and they want to give European champions a level playing field or create them. I'm not so sure whether you can really create champions by regulation, and I think the EU knows that, and therefore they try to at least regulate the American companies and the Chinese companies to create this level playing field. On the other hand, antitrust law or competition law in many ways seems to be, at first glance, too slow or maybe too troublesome. Many say that the DMA is the attempt of the Commission to rid itself of the more economic approach, because that has proven to be very troublesome for the Commission in the past, and has also, in the field of merger control, for example, led to many decisions of the Commission to be overthrown. Some claim that competition law is too slow, and they always point to the Google shopping case, but that's a very specific case, which was also slow because there was a lot of political intervention. And on the other hand, when you read the papers of the national competition authorities, they always tell you that it can go very quickly. The Federal Cartel Office settled some cases with Amazon very quickly within a year. So some of the background noise that is behind the DMA might be true and some might not. When you look at what the DMA is about and what you could criticize, I just want to pick some points. The DMA tries to solve presumed problems by targeting basically the GAFAM undertakings, but as you have pointed out, the gatekeeper, the term gatekeeper goes far further, and it is based on two quite unclear concepts, which are either unclear in themselves, like fairness, which is very wide and shiny, or which are used in a different way from traditional thinking, like contestability. When you look at the DMA, contestability is presumed because there is a gatekeeper. That is not how I understand contestability in a general surrounding. So when I want to voice a couple of points of criticism. One is the lack of, as you have also pointed out, of clear objectives, which is also blurred even further by the DMA claiming to be no competition law, even though it might be competition law in the end. And I think that's in a way by design, because the Commission wants to get the utmost leeway to say what this is all about. So that helps the Commission in a way. And the gatekeeper definition, that's the second point that I would criticize, is rather based on size than on cross-market relevance. Gatekeepers are defined without telling the companies what is the gate that they are supposed to keep. And that's an interesting point, I think, and that it would have been nice if that would have been clarified. And then the third main point of criticism is that the obligations are not only unclear, but self-executing per se rules at the same time, with the option maybe to ask the Commission, if it wishes to discuss in an Article 7 procedure how far these obligations should go, but it is not really clear in that matter too. And then there's a firework of rules that has been launched by the Commission in the past or is about to be being launched. I just looked it up, and there's the DMA, the Digital Services Act, the European Codex for Electronic Communications, the GDPR, the Data Act, the Data Governance Act, European competition law and national competition law, and it is unclear in many points how they interact with each other. And that might create problems, particularly for the small companies. Just to cut it short, the big companies, also when it comes like to the time frame, how long, there's a discussion in the trilogue now about how long a gatekeeper should have after it has been designated a gatekeeper to cope with all the obligations. And they are struggling whether it should be 3 months, 4 months, or 6 months. It doesn't make any difference. I think a couple of months don't make a difference for the big companies, for the GAFAM companies. They know that they will be targeted, and I'm sure they're already preparing. But if you have smaller gatekeepers, surprise gatekeepers, so to speak, who do not expect to be a gatekeeper, then 6 months is very, very short. And also the unclearness of some obligations will hit the smaller companies harder than the bigger companies who have been preparing, I think, for a long time. And last point, it is very hard for the companies to defend themselves, because when you look at all the presumptions in the DMA, then the gatekeeper quality is presumed based upon size, not really upon cross-market relevance. It is presumed that all the obligations in Article 5 and 6 are proportionate. It is presumed that they all are in favor of innovation and competition, and it's not even possible for the companies to prove that it's otherwise. So I think there's a lot of problems. Will that be changed in the trilogue? No, I don't think so. We can come back to that. There are some points, some screws that could be adjusted, but in the main points, I think the ship has sailed. Yeah, so far.
Yeah. May I jump in with one or two quick thoughts on that? Because actually, Torsten had said some things I think are quite important that are worth emphasizing or highlighting. One of them was to point out that we did see giant monopolies a century ago in the industrial era, in railroads and steel and oil and electricity. And we're seeing the rise of giant monopolies again. But I want to assert that we're seeing them today for the opposite reasons to what we saw them a century ago. A century ago, they were all born of supply side economies of scale, massive fixed costs, low marginal costs. So your first watt of electricity with generating plants and wires is extremely expensive. Your second watt of electricity, extremely inexpensive. Same thing with railroads. You've got to buy rights of way, you've got to lay track, you've got to put cars in place, but your second transshipment is extremely inexpensive. In the internet economy, these are all driven by demand economies of scale, not supply economies of scale or network effects. Users create value, which attracts users, which creates value. That's on the opposite side of the profit equation. The other reason this matters is that in the industrial era, they're all born of rival goods. So you're consuming the railroad track or the barrel of oil or the electricity. It means I can't. That's not true with data. You're using it means I can also use it. So the traditional tools of simply seeking to create competition on the rival asset won't create as much value. You have to create governance mechanisms that actually allow multiple parties to access that same non-rivals resource in order that we can create more value. It goes back to the point I was trying to make, that we have to ask the question, how do we create value before we create the question, how do we create competition? If we're using the antitrust tools of the 19th and 20th century, we're getting it wrong in the 21st century. And that's why I think that's one thing I think we really need to be very careful about when we're designing legislation such as the DMA.
Okay, Marshall, now allow me one follow-up question. I mean, this is particularly interesting. Also against what Torsten just said, I think it was much more clear when we talk about traditional network industries, where the gate is, what's being kept by the gatekeepers, and it's certainly the network and access to the network. But this is obviously much less clear now when it comes to technology companies and that operate in an environment that is characterized by demand economies of scale. I mentioned this before. The DMA is in a way an experimental type of regulation. From a consumer point of view, the rules should leave sufficient room for platforms to still be able to deliver high quality services. You referred to the combination of data, the utilization of data, and the importance of the combination of data for many of these businesses on one of your slides. Now, where exactly does the DMA fall short, and what types of services or aspects, ingredients to services should perhaps be carved out from the proposal?
So let me give you a few of those. In many cases, they're using insights analogous to those that they used for GDPR. Again, trying to protect privacy or create competition. And there's even reference to trying to make sure they're consistent with the GDPR. As Torsten said, there's even, you're trying to balance these multiple bits of legislation. Following the introduction of GDPR, several things happened. One, the advertising effectiveness in Europe fell. The apps in the app marketplace and the introduction of new apps fell. The investments in venture capital startups in Europe fell. And interestingly enough, contrary to the original intent, the entrenchment of Google and Facebook in the advertising market rose. The hope was that once folks could bargain with their data, smaller companies might be able to bargain with that. But what that did was it created friction in access to that data, which meant it was harder for smaller companies to gain a foothold or to negotiate, whereas the big companies already had the data. And so it was easier, and they became more entrenched in the marketplace. So in effect, what's happened is by creating islands of friction and negotiation, you make it harder to combine data sets to create value. To give you another version, we heard, unfortunately, you've got COVID. Imagine you have to ask every single person to get their data in order to do contact tracing. You can't build contact tracing in a way that's going to benefit society if you're going to have to do it that way. You want to be able to combine data sets, and then share the value back with the parties that have shared it in the first place, rather than create all these islands of friction. So it's a different way to do that. We have a different kind of proposal, which we actually think will create more value. This takes a moment to go into it, so I don't know if you want to spend time on this or come back to it. But the mechanism proposed in DMA and in GDPR both is data portability. The idea for data portability is you create competition around your data. You can pull it away and move it to a different system. That has a host of different problems. One, you lose the context. You take your social network data and it loses the post information. Why? Because that's their stuff. Their posts, their prompts, or others aren't included. So you've lost context. It goes obsolete because it's not updated in the same way. It's also inactionable or impotent in the sense you can't make a purchase, you can't receive a benefit once you've taken it away from the infrastructure in there. Contrast it to something else that we're going to describe, which is an in situ data right. Here, you would gain the right to bring the algorithm to your data in its infrastructure, as opposed to the right to pull it out of the infrastructure. What does this do? One, it preserves every bit of context. It's completely current, and you can act on all of that data. So you could make a purchase on Amazon. You could reach out to your friends with others. Amazon could recommend books to your Facebook network. Facebook could recommend friends based on your Amazon reading in this case. But it gets one step better. If this is true, then Google could now recommend advertisements based on your Facebook friends, and Facebook doesn't have a monopoly on showing you those ads. Now, what does this do? Google and Facebook are competing to show you those ads, which means they're going to share more of that value with you. Now, what we've done is we've allowed multiple parties access to the data only with your permission. And by virtue of your controlling the choke point, that is access to your data, you are going to be the beneficiary of that competition. They're going to give more of that data, or more of that data value and advertising value back to you. There's even one further benefit. Suppose that a firm behaves badly and you want to terminate their access to your private data. You can simply turn off the APIs. Under data portability, you have to take it on faith that they then destroy your copy because they've got a copy. Under in situ, they never got the data. So if you turn off the APIs, they don't have it anymore. So it gives you much more power over the data. It gives you increased privacy. It allows you to keep all of the content, keep it up to date, and competition happens on top of your data so that you'll get value. So this, going back to the original insight, what you're doing is you're allowing multiple parties access to the data where you control the choke point. By virtue of the fact that different parties can use the same data to create value, you get more value, but now you've got competition that will share it back. So this would be a fundamental redesign in how we do this. And so we're proposing this in situ data right as a much better way to implement the goals of something like the DMA or data portability, but not the current legislation. We actually think the in situ is more powerful.
Okay, thanks. No, I can well imagine that this could become an approach the US takes for regulation of data, for example. But you can address this in a minute if you'd like. But let's get to Torsten. Also, if you think about the rules in the DMA proposal that target activities to combine data, to use data, including also interoperability obligations. I heard many experts say, not only with regards to these particular clauses, but also with respect to others, that the DMA is made for violation. Now, is this an exaggeration? And if you look at the clauses on, for example, the combination of data, would companies know what they have to do when they explore new business models, or when they reconsider how their current business models operate? And also, do you feel that companies are vulnerable with respect to being exposed to lawsuits and being punished for what they do and for what they are not allowed to do anymore?
Well, I think that's a lot of questions. Let me just get to some basics with regard to all the rules in the DMA. As you've said, there are many rules that cover all kinds of activities of the undertakings, and the more general critique on my side would be that somehow the Commission took all the cases from the past that have been conducted in the field of the digital economy, and they tried to put them all into one framework and then extract the rules that have been derived from these cases with regard to very specific companies and with very specific solutions and generalize it. And that creates a lot of problems, particularly because the Commission has a tendency in a way to interfere with business models. And I don't think that is necessarily a good idea. When you look back at the Microsoft cases, the Commission wanted to create more competition, and they forced Microsoft in the very early Microsoft cases to offer Windows N without media players and other Microsoft software. Didn't work in the market. Nobody wanted that. Then they settled with regard to browsers, and they created a system in which Microsoft had to give a choice screen. Actually, that did not work in a way that was expected, because Firefox and Chrome and other browsers got successful everywhere in the world, outside Europe and inside Europe. And then, which is kind of a funny story, when Microsoft introduced Windows 7, they forgot this choice screen. And it took more than a year for anybody to notice. And then Microsoft got fined. So the Commission has not been very successful in designing business models. And the same applies here to some aspects like limiting data usage, but also interoperability. That's a very multi-sided sword. Interoperability might be good, but it might also be to the detriment of consumers if it's not applied in a very careful way. But on the other hand, it is something that has been ordered to reach in many laws, not only the DMA, but also the European Electronic Communications Codex. And so there might be an overkill in this field. So I think, coming back to your question, is the DMA made for violation? Will the undertakings violate the DMA? I think they will try to give utmost respect to the DMA in a way that they will try to be compliant with the DMA, because there are severe fines and there is a loss of reputation if you break the DMA. And also there's the specter of being unbundled, which I do not think is very likely to happen. But so I think they will try to abide to the DMA, but I'm not so sure whether they will always succeed. And then I see, and that's one of my main points of critique, I see the specter of private enforcement. And private enforcement, based upon very unclear provisions, might create a lot of problems with regard to innovation. Because private enforcement is not really, that's a romantic view that private enforcement is about protecting competition. Private attorney generals, white knights, right to court to protect competition. I don't think so. Private enforcement is primarily about private interest, personal advantage, and lawyers' fees. And if you're lucky, then as a welcome side effect, competition is protected. And so I think it is very important to clearer shape the question of whether private enforcement will be possible based upon the DMA, and who bears the burden of proof. And I looked at the documents from the trilogue, and that goes back and forth. The Parliament wanted more private enforcement, the Council wanted a little less, and even the last drafts of early March do not really include any answer with regard to that question.
Thank you. I mean, one side note from my side, when you run through the obligations in Article 5 and 6 of the DMA, you can easily come to the conclusion that the rationale of the DMA is actually to increase the number of lawsuits, and it's about lawyers' fees as well. But maybe that's a bit too cynical. But speaking of cases, Thorsten, I heard many people say that ex post enforcement against large digital platforms. It took too long. It was too slow. Now, if you think of, let's say, Google Shopping, the Android case, do you think there are merits with the proceedings in terms of the effectiveness and the remedies that they brought to the front?
I think the DMA has many aspects that point in the right direction. It sometimes takes too long. Ex post scrutiny is troublesome, and it takes too long. It's hard to prove. So some adjustments with regard to the burden of proof and also with the speeding up of the procedure are urgently necessary, I think. Not all cases take as long as the Google Shopping case. It took 7 years until the Commission reached the final decision, and then it went to the court. There's the first decision now, but the Court of Justice might decide, so it'll take more than a decade until we finally know whether everything was correctly assessed or not. And so that, yes, that often takes too long, but there are other procedures which might help. For example, I work a lot in the field of merger control. And you cannot simply take all the rules from merger control and put them to the field of abuse. I remember there was an international cartel conference of the Federal Cartel Office in which a politician spoke, and he said, oh, well, merger control takes 4 months. We should do that in the field of abuse control as well. That's a too complicated field, but you could maybe take some clearer groups of abuse, what the DMA has done, and then set them in a framework that resembles merger control in a way so that to give a short procedure that takes a couple of months, and that is possible. Monty wrote a paper about that, and I elaborated on that as well. So it would be possible to create a procedure that aims at commitment decisions, and that includes the undertakings as well as the Commission, but shifts the burden of proof more to the undertakings, thereby speeding it up and making it easier for the antitrust authorities to decide about these cases. And so if you take a bit DMA, a bit of the German Section 19A, and a bit of merger control and mix it, then you might get a system that works, and it might in the end work quicker than the DMA, because you would not have these lengthy and troublesome legal disputes that might follow some of the DMA obligations.
Okay, before we turn to Marshall, Thorsten, I have one more question to you, because you were referring to Germany's revised Competition Act. It's often said that in Germany, gatekeepers would have better means to explain what they do and have a proper means for regulatory dialogue. Now, the contrary is said for the DMA, which is often said to lack a genuine tool for regulatory dialogue. Is this actually true, or is this also kind of an exaggeration?
No, I think that is true. I mean, when you look at the German system, the first step is similar. Gatekeepers are designated. The criteria are different, but in the first step, and the Federal Cartel Office has done so, and it has done so quickly. All 4 GAFA undertakings have been designated gatekeepers according to the German law already, although that has been enforced for just 1 year. So they acted quickly. And then the second phase is different, whereas in Europe, gatekeepers have to oblige with all the obligations by law, and the regulatory dialogue is only possible with regard to Article 6 obligations. The companies may apply for a regulatory dialogue, and the Commission has to make a decision whether it wants to grant this dialogue or not, and it might say no, and there will be no decision. In Germany, it's different. The Federal Cartel Office has to follow a set of obligations that is laid down in the code, but then it has to make a decision. And the companies are entitled to talk to the Federal Cartel Office and to discuss and shape these obligations, which might help because they know what they have to do. And then at the end, there will be an obligation, which in many cases will be similar to commitment decision. And then only after that, after such a decision has been made, private enforcement will be possible. So the undertakings will be bound to the decisions of the Federal Cartel Office. And if they violate these decisions, then private actions may follow. But they are not bound to the legal provisions which only set the frame for the decision. So I think this system is better, and it will, and it gives you much more opportunity to defend your rights, and also to prove maybe that some behavior that the Federal Cartel Office deemed to be anti-competitive, in effect, is pro-consumers and pro-innovation. And they,
okay.
Yeah.
Yeah, no, that's my impression as well. The German approach seems to be much more consistent at several stages of an investigation and enforcement by competent authorities and also private enforcement. Marshall, now that we've heard what Brussels wants to implement, what's been implemented in Germany, it all happened against the background that in many parts of the world, many people think that large technology companies are too big and too powerful. Now, what is actually going on in the US? Do we have a similar debate? And can you tell us a little more about US endeavors to address issues in the digital economy, particularly companies that operate in markets that are characterized by network externalities?
Absolutely, absolutely. So I'm happy to pick up on that. Before we do that, let me pick up on one thing that Torsten said. I thought was actually quite interesting. I do think it's really important to ask the question, when is merger and acquisition or combination pro-competitive? And I actually think the competition authorities really do need to be thinking about when that's the case, or many counterfactuals. If I may give just one example, there's a fascinating case out of China. I don't know, Alibaba is the largest e-commerce giant in China. Pinduoduo was a small startup that did group buying as a way to do that. If Alibaba bought Pinduoduo, that's clearly anti-competitive. It's not a good thing to have happen. But Tencent, which is the largest and has a big social network, did not have an e-commerce presence, then partnered with Pinduoduo and made it more competitive against Alibaba. So it was another giant platform, but not operating in the same market. And so it was able to provide resources to a small company to make it more competitive and then actually create some benefits. So that's a really interesting case in which a giant platform acquiring something else, but not in the same space, was actually quite valuable. And I think looking at those alternate constellations or alternate configurations is really important in trying to figure out whether or not these create value or not. So on to your question about US legislation. It's not quite, US legislation is not quite so prescriptive in the sense of determining the exact size of gatekeeper platforms, or determining by size or other things. I actually happen to have, it's funny you should ask, I actually have one slide that summarizes a lot of legislation. I hadn't planned to show this, but if you'll give me one moment, I can make that available. This is legislation that was just introduced in the last semester of House and Senate. And so they're actually similar in many ways, but they tend to be a little bit smaller rather than this large legislation. So there have been things to reduce, as I say, one introduced the Access Act to reduce switching costs, make it easier to move from company to platform. Non-discrimination conduct, that's actually quite similar to the self-preferencing clauses. Eliminating conflict of interest is another version of that in platform monopolies. Another one is they tried to increase the resources available to the antitrust enforcement or to the FTC. As you may know, Lina Khan has just taken over, and she's a member of the, shall we say, the new Brandeisian school of regulatory reform. And this is one where she and I think Tim Wu think bigness is bad per se, rather than so competitive in that. So there are some things there where I may not necessarily agree with all of those. I do think we have to watch where bigness actually gives them market power or market failures as a result of that power. But bigness per se, if it's properly won because you actually have better products and services, we really do need to protect the companies that are innovating and providing higher quality. So I think that's something that does need to take place. But this is a summary of some of the things that are taking place. And there has been a sea change in what the approaches have been based on who is now chairing the Federal Trade Commission, now Lina Khan, as opposed to someone else. And she has what has become a famous article, the Amazon paradox, getting too big and then actually crushing some of the markets is one of the things that she's been doing. And she's been trying to make it harder for these big companies and being much more interventionist. So I think I would agree that there are problems that need to be solved. I disagree that bigness per se is bad, and I really think that it's essential we protect the innovative mechanisms that lead to better, higher quality products at lower prices. So these are the things where I think the consumer welfare tests should not be abandoned. Rather, we should adapt them for the realities of the internet economy as distinct from the industrial economy.
Okay, yeah, thanks for this overview. How would you assess the chances for success of either one of these acts, given the majorities in Congress these days?
That's a fair question.
Just from a bird's eye perspective, because I fear that there are many people who are on your side, I would say, in favor of the consumer welfare test, in favor of innovation, sharing the opinion that more regulation is not at all, or not necessarily conducive to innovation. My impression is to give you my impression right away is that we will not see much in terms of similar legislation in the US at any time soon. Maybe I am wrong, and I would say that this is actually a blessing for US American technology companies of any size, not necessarily only the big ones. But what's your take on it?
So let me concur with you. I think we're unlikely to see much legislation in the near term. I think to the extent it may follow a little bit more the UK model, trying to set forth broad principles as opposed to setting forth specific behaviors. So the DMA and the DSA are very prescriptive in behaviors they allow and they disallow, whereas I think it'll be more along the lines of setting forth principles. The one case where there might be an exception, we might see some movement, is a somewhat different area, which is in the United States, it's Section 230, which is on the platform liability for user-generated content. I've heard that there may be some movement in that area. It is you no doubt familiar that the politics are quite polarized in the United States at present, but it's interesting. Both sides want to revise Section 230, but for very different reasons. So the right wishes to revise Section 230, which is again shielding platforms from liability for user-generated content, because they feel too much free speech is being violated and the platforms are exercising their right of editorial removal too frequently. So they want to reform, the right wants to reform Section 230 to protect free speech more. The left, on the other side, wants the platforms to remove more misinformation and harmful content. So that, and this is again, the platforms are given complete discretion to do that. Again, as long as it's legal, they don't have discretion if it's criminal conduct or sex trafficking or things of that sort. But they have broad latitude to take down pretty much what they want outside of that. And the left wants to remove more of this misinformation. I anticipate we will see some movement on Section 230 reform as one of the elements of that.
Okay. Yeah, thanks for this early assessment. Now we have one question from the audience, and dear audience, please put any question that you have in the chat box so that we address them. We still have a few minutes left. Karina Stan is asking, what are the challenges for implementing friend market access? Thorsten, could you take this one, or Marshall?
Well, that's actually one of the most unclear points. There are several obligations which include friend obligations, and friend is, in general, everybody would agree that if access is granted and if some conditions have to be defined, there must be friend, which is fair, reasonable, and non-discriminatory, which is kind of a basic set of rules that is also applicable in standard antitrust law. But what exactly does friend mean? And we have had a lot of discussions of the friend standard, for example, in the field of standard essential patents. And one thing that was derived from that discussion is that there's not a single friend point, but there might be several sets of friend conditions, and you can really discuss about what is friend. There's a famous case in which Motorola and Microsoft fought against each other with some very interesting twists during the procedure, which I will not elaborate on, but it was about some video codecs that were built into the Xbox, Microsoft's Xbox, and Motorola had some patents on these video codecs. And Motorola considered $1 billion a year friend. Microsoft considered $1 million a year friend. And so you see how far that spectrum goes. In the end, a district court in Washington settled that to $1.5 million, I think. So this is such a wide array of possible solutions. And I think the Commission at least has to give some guidance in how to define friend in that context. To leave the companies alone with the friend standard will really, that is made for violation and that is made for legal disputes in that field.
So if I might jump in, I'd take 2 minutes to actually give you what I think is an answer on that, because I think that's a fantastic question. And I actually think getting that right could create immense sources of value if it were done well. And I don't think the legislation has gone far enough in figuring out how to do that. If I may, let me take a moment and offer what I think is a combined computer science and economic solution to that exact problem. So let me see if I can share screen one more time. Let's see if I can illustrate this for you. So let me know if this shows correctly. Can you see screen? I'm going to try to illustrate this to give you just a moment for it. So is this visible? Matthias, whatever.
Yeah,
so
yeah.
Imagine we take the infrastructure on the bottom. So that would be any of the things that have been, the social networks on the bottom, the operating system, the marketplace, what have you. And then you separate the apps or the value propositions on top. What I would suggest is that each of those things needs to have an API barrier to them, which gives them mediated access to the infrastructure underneath. And so it becomes a legal as well as technical firewall between the infrastructure itself and the value propositions on top. The way we might implement friend access would then be to set that API layer separately in a separate division. And then anyone, including the firm's own apps, are able to access it under the same data terms and under the same pricing terms. So you have access to the same data and the same price menu, and this is all published. And it could actually, you can either bid for it, what have you, in order to gain access to it, but everyone's going to have to access the infrastructure and the data and the prices at exactly the same price maximum. That applies to the internal divisions as well as the external divisions. Now we know that it's fair and it's the same that everyone's working on. And I would think that this also provides for the resources that pay for the infrastructure itself. The infrastructure is being paid for both by the internal app as well as the internal app, again, under exactly the same data terms, under exactly the same pricing terms. But it has to be implemented at the API layer in order to make this feasible, so that you could even track the data flows across that API membrane, so that we have exactly identical access to it. So I think that would be a way of implementing that friend access. I think it's a great question. I think it was an absolutely fabulous question.
Yeah, it was a fascinating reply. I think this provides sufficient stuff for a separate seminar, and I think there will be opportunities to discuss this in more detail in the future, given that we have to deal with IP law revision and after all also the EU's recent Data Act. But anyway, there is now one more question that's more kind of a, let's say, general question, I would say, and it is about developing countries and their capacity and the lack of capacity to, let's say, implement and enforce similar regulation. Now, Thorsten, let me address this question to you. Given that the EU is about to set up a new group of experts, a task force, of which many say it will not be sufficient. It will not be large enough to deal with all of these complexities and difficult question challenges that come with the DMA. How should a developing country, a smaller country, approach competition law or regulation of gatekeeper companies, given the capacity constraints in these countries? Should they do nothing, follow a US approach, or at least try to copy paste the EU's approach?
Copy paste might work in some respects. I mean, when the EU was extended to the Eastern European countries, that's actually what the Eastern European country, being far from being developing countries, did. They simply took over the framework of the EU, and then they could reach out to the rich casework that had been done in that field and look at these cases, what developing countries could do to look at the more developed systems, also with regard to the cases, and maybe try to create some rules in that field. I would say they should stay with more general rules, like we have done in Europe and like the United States have done for 140 years now, because it gives more room for finding their own solutions, but at the same time taking over, learning from the rich experience of the so-called more developed countries. A very important aspect has always been, as I work at the university, as young scholars from these countries coming to Europe, coming to the United States, to Japan, to Southern Korea, and to learn from the experiences in these countries, and also to enrich our experiences by bringing ideas from their home countries. I've had many Chinese students, for example, while the Anti-Monopoly Act in China developed. And this is a back and forth, a taking and giving, and that has been very inspiring for both sides because you see very different ways. I would not take over specific sets of rules like the DMA. That's far too specific. I would rather apply a system that is based on general rules and then look at the cases and see whether they fit within the frame of the national legal system. And then you do not have to develop everything from scratch, but you can learn from the experiences and also from the mistakes of the so-called developed countries. When you look at German energy law, for example, I once attended a conference and an economist spoke and he said, when you look at all the subsidies in Germany and what was done in Germany, it's good for the world. They can learn from us how not to do it. So that might also be a way to learn from the experiences of the past.
So let me concur with Torsten. I think using general frameworks is probably the right idea, and certainly learning from the experiences that have come before. But I want to go one step further in the sense that developing countries, for the most part, just don't have the market power to make Facebook or Google or Amazon do anything. The markets are too small. So I think the way to handle that is to band together with other developing countries so that you effectively get more voice, get more market power, if you will. And you can also try to collect the concerns of the multiple developing countries that would be facing these issues. And then embarrass them when they behave badly, I think is a good way to do that. But I think it would be important for the developing countries to form coalitions to negotiate with these firms in order to get them to actually modify their behaviors. Do learn from the experiences of the other companies, do learn some general rules. If you try to make things too specific to your own country, I honestly think it's just not going to work. I just don't think there's sufficient interest or market power or economic clout to make it happen. But if you band together, I think that it'll give more of that power. And I think to embarrass them for not behaving well, I think that's also a good possibility. So I think these are other leverage points that we can apply.
Okay, thanks to both of you. Now let's come to a close, and I would like to ask the final question to each of you, and that is basically, let's assume for a moment that there is still space for amending the DMA proposal. Could you name 3 aspects that you consider most important for changes, either in terms of additions or in terms of carve-outs?
Well, I'm happy to jump in on that. Personally, again, I've got a bias in this, but personally, I think the most important addition would be things like these in situ data rights. The reason is, again, I think it solves this multifaceted problem of how do you get the most value out of data? So how do we create value? And it also solves the problem of getting that value back to the users that provided that data. And I'm not sure the other mechanisms do that. So I would strongly advocate for, among other things, these in situ data rights. There's a second attribute of this, which we didn't mention, which also solves the oversight problem. Many of you may have heard of the NYU and German studies that were looking at false ads or misinformation on Facebook. And they got permission from users to monitor the accounts, and Facebook terminated that access on the claim that this was private information of the advertisers. That's not fair game at all. If you had the right to allow a Consumer Reports or a research group or a German government or anyone else to observe what you're being shown, what misinformation is doing, that gives automatic oversight. And even if you don't have the expertise, you can invite an expert in. So what this does is allows oversight in a way that you don't have to be expert, and the competition authorities don't have to be expert, but the other parties who do have the expertise can sell those services and provide that oversight so we can know when they are behaving badly. So I think these are mechanisms that if you implement these in situ data rights, we can create more value, we can create oversight, and we get more of that value back to the users in ways that creates a healthy ecosystem. So that would be my recommendation, and that would basically be one recommendation.
Well, if I could, if I had 3 wishes with regard to the DMA, one of the wishes would be that there should be a more consensual procedure that would lead to decisions by the Commission rather than self-executing rules. But I think, as I said, this ship has sailed. So at least I wish for more clearer provisions, and I hope that the Commission will work on some provisions and maybe consider or reconsider some provisions. They have already done so in the last phases of the trilogue, for example, with regard to interoperability, which is really can be very problematic and anti-innovation if you tighten that too tight. The second thing would be that I hope, and that's the second point that's still being discussed, that the DMA is applied in a centralized or harmonized way by the Commission, and that the national authorities are basically should be there to assist the Commission and not enforce the DMA on their own, because that will create a very disharmonic way of enforcement. And the third point would be, as I've said, private enforcement. If private enforcement is made, the first thing would be make clear whether private enforcement is possible or not. That would be the first question I would ask. I would like to know whether it's possible or not. If it is possible, then I would strongly advocate that to find some rules about the burden of proof. The DMA in the last versions I've seen sounds as if the undertakings, the gatekeepers, have to prove that they did not violate the DMA and that they did not harm competition and consumers. And this might intrigue many attorneys and many other companies to sue, hoping for damages or for a settlement, which is the solution in most cases. I think that to keep the burden of proof with the plaintiff would help at least a little bit if private enforcement is possible. I would rather tend to not privately enforce the DMA until some experience has been gained, and then we can reconsider that.
Matthias, you're on mute.
Pardon. Yeah, thanks a lot, Thorsten. On the latter point, I think it might take years to gather sufficient experience. But anyway, I think we've had a very, very rich and fascinating discussion in many respects. I hope that we, in a way, encouraged the European Commission, but also policymakers in the member states to reconsider certain aspects of the current DMA proposal. I also hope that we, in a way, empowered companies, not only the large ones, but also smaller ones who consume digital services, to question some of the rules or even seek legal action in some instances. And I also hope that we, in a way, translated the message that there might be need for having a transatlantic regulatory dialogue on good regulation for digital markets on the basis of what the OECD calls good standards for good regulatory design. That said, I would like to thank you very much for your interventions, your comments. It was a very good discussion. And I wish you a good night and you a blessed day, Marshall, in Boston. And it was a real pleasure. I'd be happy to have you again at one of our ECIPE events. Thank you very much.
Thank you for having us.
Thanks for having us. Yep. Bye.
Bye-bye.